£600,000 in damages.
This is the High Court, where QCs and judges decide who pays and who gets paid.
If they said to me, you can have £1 million, that might be tempting.
Some people find what newspapers print or television says unforgivable.
Hey, Uri, what's this thing with Michael Jackson? Is it true?
Some people will do anything to set the record straight.
Worst case scenario is it goes away to trial and I don't sell the house. Where am I going to get 200 grand from in November?
So why get yourself into this position? Why take the risk?
I want justice. However much I don't want to go to court, I will.
So be careful what you say. See you in court may be the most expensive words you'll ever hear. Tonight, two men speak out in the public interest and then desperately try to defend themselves when their targets sue them. Science writer Simon Singh is being sued by the British Chiropractic Association for questioning their treatments.
We support our friend Simon 100% in this ridiculous case that cracky does not equal medicine. And am I in the case now, am I? Am I in that, am I?
And the costs he faces are enormous.
If I lose the case, that could be a bill in excess of £250,000. We have to test homeopathy with an open mind. I've been testing it during the course of this lecture. You may have noticed I've taken some of these homeopathic sleeping tablets. And I'm seeing if I fall asleep before any of you do.
Simon Singh is passionate about science and delights in both popularising and using it to debunk what he thinks doesn't stand up to scientific scrutiny.
Now, it sounds utterly incredible and ridiculous, but in science you have to be open-minded.
At home, Simon's walls testify to the award-winning books and television series that also earned him an MBE. But in April 2008, Simon wrote an article in the Guardian newspaper about chiropractic medicine in which he questioned some of their treatments.
There are people who claim that they can treat conditions not related to the back. Childhood conditions as well, things like colic, asthma, ear infections. And for me, that's not substantiated by evidence. For me, that's really concerning because we're talking about childhood conditions that are sometimes quite serious. So the point of the article was to make people aware that these claims are made and to discuss the evidence or lack of evidence surrounding these claims.
He invoked the wrath of the British Chiropractic Association, who promptly picked up the phone to their lawyers and sued.
Smartest thing in the world would have been to have backed down. I think settlement would have meant a payment of a few £1,000s, nothing big, and an apology. But the problem then is that any other science journalist who wants to write about these kind of things realises that if you do write about it, then somebody threatens you with libel, you have to back down, what's the point? It has a chilling effect on journalism.
A year after his article was published, the decision to defend himself brought Simon to the High Court in London.
It's a day I won't forget. The judge was going to rule on the meaning of the article.
Simon believes that what he wrote was fair comment based on his knowledge of chiropractic treatment. The judgment went differently.
So I came out of the Royal Courts of Justice somewhat shell-shocked. This was the nightmare scenario by barristers and my solicitors. Their jaws dropped. Things hadn't just gone badly, but had just gone catastrophically badly. What Justice Eadie ruled was that I was calling chiropractors deliberately dishonest, that I was accusing them of peddling treatments that are not only not backed by evidence, but which They knowingly promote, knowing that there is no evidence. Could I appeal the decision? And Justice Eadie actually said, no, I'm not going to give you permission to appeal. Because for him, it was such an obvious decision, it wasn't worthy of appeal. For us, it needed to be appealed. If I lose the case, I'll have to pay my own legal costs and I'll have to pay their legal costs. And that could be a bill in excess of £250,000.
The first step in Simon's fight back is to work out a way with his lawyer to win the right to appeal Mr. Justice Eadie's decision in favour of the British Chiropractic Association.
Well, we've got to attack the judgment of Mr. Justice Eadie, and we've got to say what we think the right answer should be.
And so that'll say things like, we don't believe that Justice Eadie necessarily took into account phrases used earlier on in the article.
I think that's our point. It's a point of libel law that you have to look at the whole article. We all think that the article, in the light of the rest of the paragraphs, the somewhat harsh things you say at the start are softened. Yet not a jot of evidence, for example, and bogus treatments. You actually explain why they are. We need to be able to say that they have misled the public on colic, sleeping and feeding problems, frequent ear infections, asthma and prolonged crying. Now, we've actually got an admission from them in the reply that for two of them, they don't have any evidence. But we do, of course, have the problem that a decision like this is difficult to undo. It really is, litigation with the knobs turned up to 11.
Oh, hi, it's Simon here. Are you still OK for the press conference on Wednesday? Signatories are looking great. We're just really gearing up now for next Wednesday, so it's all looking good.
Simon Singh is also looking for help. A pressure group called Sense About Science has taken up his case, saying it shows how the libel laws are being used to silence doctors and scientists who want the public to be warned.
Correspondence from the big papers.
Right.
I'll get it on board.
I can see all the profs and the journalists and the editors. So we're over halfway to 100.
That's right.
Harry Hill, I had him on my list because he's a background in medicine and somebody would be great to have on board. And Darren Brown's here. He's the latest addition to the list.
And Dara Breen came to us as well.
Yeah, no, I mean, Dara talked at length about science and rationalism and alternative medicine. And so I know this is an issue that's close to his heart. It's an extraordinary mix of names. It's brilliant.
We think we're in this kind of movement towards greater openness, much more transparency, an age of informed consent. And in fact, actually, what we've got is something that's struggling very hard against that and threatening to completely chill it. You have to remember, someone can bring a libel action against you for anything. Whether that then stands up in court is another matter. But of course, you have to pay all the money to get to court, which is ruinous for most people. So the likelihood of them winning at shutting you up is very, very high.
Appropriately, Simon helps launch the campaign with a press conference at the home of scientific debate, the Royal Institution.
Sorry, we're obsessed with the costs of this, but just in terms of your personal liability for this stage now.
I think right now it's £100,000.
Yeah.
If I were to settle, in addition to that, I'd have to pay the BCA's legal costs.
And these costs are already running to over £200,000, which is not surprising given the current English libel system.
The cost of an English libel case is 140 times greater than a European average. There's something seriously wrong here.
There's a famous episode of South Park, which you can see on the internet, about Scientology. And there's a running gag in the cartoon about Tom Cruise. At the end of South Park, the Tom Cruise cartoon character storms out and turns to the mocking children of South Park and says, "I'm going to sue you in England." And I would like to make the point that's not very funny, actually. The fact that joke's made in South Park is also a sign of the rising international concern about what the English legal profession is doing to freedom of speech. The most famous case is Roman Polanski, who fled from America after accusations that he'd had sex with a 13-year-old girl. Then Vanity Fair a few years ago printed a piece about him which included allegations of a sexual nature. And he sued, and it went to the House of Lords, and the House of Lords said, Oh, well, even though he's on the run from accusations of child abuse, he can still sue in London. And then Polanski says, oh, but actually I can't come to London, because if I do, I'll be arrested and deported to face accusations of child abuse. And Laura said, oh, never mind, you can do it on a video link from Paris. And he did, and he won.
Costs in the case were estimated at £1.5 million. Cheltenham and its Science Festival represents the way Simon Singh thinks science should be debated, openly between experts with the public judging.
He was an astrophysicist from the 1940s, a chap called Fritz Zwicky. He invented the notion of dark matter. But the thing I really love about Zwicky was he came up with a wonderful insult. If he didn't like somebody, his insult was to call them a spherical bastard. By this, he meant a sphere is a geometrical object which looks the same whichever way you look at it. And a spherical bastard is someone who's a bastard whichever way you look at them.
This Saturday night cabaret has been organised to highlight the need for libel reform and raise funds for those, like Simon, who find themselves on the wrong end of a lawsuit.
I was going to talk about libel, which is not an entirely riskless activity, especially given that there's at least one Bentley-driving millionaire at this festival who has himself threatened me with legal action. Ideas in science and medicine improve because they're criticised. That's not a sort of side issue. That's the core of how ideas progress. If you go to any academic conference, you'll see scientists being absolutely vicious with each other about their ideas. And that's because it's really important that our ideas improve, because in science and medicine, you can do great harm, even when you think you're doing good. And I'm sure that most chiropractors do think that they're doing good.
Well, that's very interesting, Doctor, with the complex stuff. But now, in the name of balance, we must turn to some witch doctor, quack, homeopath, horseshit peddler on the other side of the debate, right? Now, I've nothing against well, I do. I can't take it. It's water and sugar cubes. I'm not a pony, right? You know, if I'm sick, give me medicine. Or, do you know what I mean? Don't stroke me on the snout and wish me good luck, right?
What Simon was doing was a more rigorous form of the kind of work that comedians have been doing in a more shambolic but kind of passionate and gag-filled way for a while now. There's been a general movement about things like bad science, whereas as I put it, we're too old for fairy tales, and isn't it time we stopped?
We support our friend Simon 100% in this ridiculous case that he has up against him by the Chiropractic Institution, who are just trying to bully people into pointing out that cracky does not equal medicine. And am I in the case now? Am I in that? I did 23 weeks as a chiropractor. Ever tell you that? The cracked me and pushed me and cracked me and pushed me in every direction. And then eventually went, do you sit in your wallet? And I went, yeah, that'll be the problem. Right? Tear those bastards down, yes. And when you're there, get my cash back off them. Where you're at.
Pressing on with his battle to win the right to appeal the judgment against him, Simon now needs the skills of a libel barrister to find the best arguments for overturning it. Fortunately, given the costs Simon already faces, he's found a barrister who believes in the principle of his case and is prepared to help on a CFA.
The comments I've had from people who had read the judge's judgment and said to me, oh, I think the judge was right. When they've then been shown the surrounding paragraphs,
right,
their view has changed. And I think, the context is the single most important thing.
When you talk about definitions and meanings and so on, and bogus, you sort of seem to accept that bogus means sham, counterfeit, and then it's a question of, is the person knowing that what they're offering is a sham and a counterfeit or not? And there is another use of the word bogus. Bogus just means bad, poor, unacceptable, doesn't do the job.
The most important point I feel about bogus here is that you explain why you say it's bogus.
Yeah, I didn't say... I know... I think this is bogus, not because I've seen a letter where they say, this stuff doesn't work, but we're going to keep... I know it's bogus because it's yeah.
It's as in worthless, isn't it?
Yes, exactly.
And I think the problem here was that the judge allowed for only one meaning. He gave his meaning of it and didn't allow for the looseness of language like that. I feel quite strongly that we've got very powerful arguments. This is not just somebody who is tasked by the editor to write a piece on something he knows nothing about and does a bit of search on the internet and so on. This is someone who knows an awful lot about the subject. It's so important to know what the boundaries are of free speech. Arguing about what the meaning of words is, arguing about whether it's a comment or an assertion of fact. I think that if they say this is comment, then you're over the hill then, because it becomes a matter of your opinion.
As long as we get the fair comment, we're
I think that's the most
we've got the wind
important
behind us.
element, yes.
So Nick called me this morning, about half an hour ago, and...
Simon Singh would agree about the time and the stress. It's almost 2 years since he was first sued. Essentially funding the case himself, he knows only too well the financial pressure, but he's attracting more and more public support.
Cheers, bye.
These are the Westminster skeptics. They campaign to ensure that public policy is based on the facts and nothing but the facts. They're discussing the case of Simon Singh.
A year ago, nobody cared about the issue of libel. The people that are here, in fact, are the people that have blogged about it, twittered about it, joined Facebook groups, told their friends. And the fact that this is now on the political agenda is one of the things I think we should be celebrating tonight. The pressure of libel is to take out the guts of the article. So in my case, if I'd not mentioned the British Chiropractic Association, I probably would have been fine. But I thought they had a case to answer, so I wanted to mention them specifically. Earlier on in the article, I called them wacky and fundamentalists, chiropractors. Now, maybe I can be sued for saying that. So all along the way, you just have to take out and take out and take out until you end up saying virtually nothing. The chiropractors themselves, they are getting so much bad press. A very large number of their members have started withdrawing the claims that I was complaining about.
There's no question Simon's case has made the public more aware of the flaws in the current libel system, but he's still struggling to win even the right to appeal. Turned down twice before, tomorrow is his last chance. His lawyer's going to court to make a 30-minute appeal in person.
The odds are against us now more than ever, yes. I mean, I'm not saying it's without hope.
If we get the Court of Appeal to look at this seriously, then we're in with a good chance. The problem is getting them to...
I'd say we're in with a better chance. I wouldn't necessarily say we're in with a good chance.
If we are turned down tomorrow, and it's very difficult actually, we're pushing a snowball up a hill. We've already failed to get permission from the judge, we failed to get permission from the single Court of Appeal judge. This is last chance saloon. I think the Court of Appeal should give permission to appeal, but I have that natural pessimism, which I suppose drives one on to try and do well. A natural pessimism that we've lost twice on appeal, and, third time unlucky.
The rules only allow Adrienne 30 minutes to state her case. The judge makes his decision there and then.
Thank you very much as well, Conor. Thank you very, very much. Fortunately, he sided with us and agrees that our points are arguable. And I have got a big grin on my face, but I'm trying not to get too excited because we've now got to go to appeal. We've got to win the appeal on meaning. Oh, hello, Mum, it's Simon here. We were in court today, my legal case. Yes, and we had a good result, very, very good result.
It's the morning of Simon's right to appeal hearing, and he thinks the public campaign has really helped him.
That seems to have come together to make people realise that it's time that we, in England, we deserve to read the truth. And in order to do that, we've got to allow journalists and writers and scientists and bloggers to be able to write the truth. What happens today is just extraordinarily important. Thank you very, very much.
The fact that 3 of the country's most senior judges have been assigned to hear Simon's appeal clearly shows the courts are taking the matter seriously. But he still has no guarantee of the outcome. After a day in front of the judges, things appear to have gone well for Simon.
He made references to the cost and the time, not just my cost and time, but also actually the BCA who are racking up costs and time. And it's just the whole thing kind of just should never have really happened, or should have been resolved in a much smarter, quicker way. And the whole thing about libel is it's not about what I or other journalists or researchers or bloggers can write. It's what the public is eventually able to read. And it's the public that loses out.
I think they came in thinking, why in a society like ours should one not be able to write this sort of material?
And somebody sues you.
One hates to come away feeling that things have gone well, because you just know how more painful it will be when you get the judgment that drops you in it again. But I felt that it had gone really well.
Realising the importance attached to this judgment, the judges will take a month before they give their answer. Time for Simon to reflect on the costly decision he made 2 years ago.
If I was a 25-year-old journalist with not much money to my name and not much support, and I was put in this situation, I'd back down straight away. I'd have no choice but to do that. But I'm not in that position. I'm wealthy enough and old enough and big enough to be able to fight this. If I don't fight it, then I was going to say I'd be spineless, but in a chiropractic context, that's not quite the right phrase. It would be, if I can't fight it, then who can? Thank you very much for coming along. It's not good news, it's great news. We've actually got an extraordinarily positive ruling on our side.
The Court of Appeal upheld our application that the words bore the meaning we said. They also upheld our application that the words complained of a comment. What that means is that Simon just has to prove that this was an honest opinion he could reasonably have held on the facts available.
The serious concerns the judges raise in their ruling about how the libel laws are currently being used has given strength not only to science writers specifically, but also to the wider political campaign for libel reform.
My first son was born 10 days ago, and Sense About Science gave me this wonderful little keep low, keep low. And I can see from his eyes he does support the campaign. So we've got a victory today, which is fantastic, a victory on the meaning after 2 years. The case could go on for another 2 years. To decide the meaning of these words will have cost £200,000. Now, fortunately, we're not going to have to pay that now. When I say we, I mean I.
Are you going to write more about the BCA or about chiropractic after this?
Probably not till the case is over.
Simon's got 2 things. He's got a wallet and he's got balls. That's why this case is here.
You can get a T-shirt which has that.
I think what this means is that every scientist who's getting sued, any time the BMJ or Nature or Lancet get a lawyer's letter, they should be able to rely on this case and say there's now a presumption that this is comment. I think people will be referring to it as the Singh comment. These are paragraph even in a textbook now.
So I've always dreamed of being.
Yes.
Exactly. I've got to be a footnote in a legal text.
Exactly. It was a great feeling. I think it was the best day of my professional life.
Libel cases are notorious for going on for years. In Simon's case, he's become a father in the time it's taken just to overturn the original judge's decision.
Oh, we've got a smile. It's very extraordinary. So this is him. This is little Harry. The appeal court ruling was fantastic from my point of view. It said that the meaning of my article was exactly what I said all along.
That is not the outcome that the BCA had expected, and they have now decided to drop their claim completely to avoid further legal costs being incurred by either side. The BCA also noted that Simon Singh had said publicly that he had never intended to suggest the BCA had been dishonest.
I've no doubt at all that the bandwagon was very, very effective in making the judges realise that the law needed an adjustment. Interesting that they said in their judgment that they had no doubt that there had been chilling of writing in this field. This is not about celebrities or who's having sex with whom. This is about medicine, it's about science, it's about better understanding, better ideas, better debate, better advances and progress in these areas. And that has to have some freedom in which to do it.
The reason I wrote the article was to make people aware of chiropractic. I think 1 in 4 chiropractors are currently being investigated for making misleading claims. And parents who want their children treated maybe will think twice before going to see a chiropractor. So that's great. That's a real bonus in a way.
But Simon's now found out that in libel, a victory doesn't deliver exactly what it says on the tin.
They now have to pay my costs because they started this whole nasty business. A victory means that I will probably get about 70% of my money back. I'll lose 30%, which means I could still be £50,000 out of pocket for having won a fight that I never wanted in the first place. It doesn't matter if the sting of what you're saying is actually true. It doesn't really matter if the broad emphasis of your article is in the public interest. If you can just be tripped over by something that makes your life hell for 2 years, costs you tens of thousands of pounds, even if you end up winning, that's going to mean that life for journalists, bloggers, academics is just made that much harder. And who loses out in the end is everybody.